Judgment in the appeal, Batley Pet Product Limited and North Lanarkshire Council.
Lord Hodge will summarise the judgment which he has prepared, which again and happily is the unanimous judgment of the court.
This appeal concerns the Scots law of landlord and tenant. It raises two issues of interpretation of contractual documents. Batley, the appellants, were tenants of commercial premises which they sublet to North Lanarkshire Council. The council had obtained permission to alter the sublet premises in a minute of agreement, which imposed on it an obligation to remove the alterations and to restore the premises at the end of the sublease, if the tenants and mid-landlords, that is Batley, requested them to do so. The two issues of interpretation were, first, whether in the sublease Batley had to give written notice to the council before the end of the sublease of the council's obligation to keep the sublet premises in a proper state of repair, and secondly, whether in the minute of agreement Batley's request that the council remove the alterations had to be in writing. Before the sublease came to an end, Batley had appointed a chartered surveyor to prepare a schedule of dilapidations. Batley avers in its written pleadings that the surveyor spoke to an official of the council and intimated that Batley required the council to remove the alterations and reinstate the premises. But Batley put nothing in writing before the sublease expired. The council refused to remove the alterations and reinstate the premises because it asserted that Batley had failed to give it timely written notice that required to be done. Batley therefore raised an action against the council seeking damages for breach of contract. Temporary Judge Wise allowed Batley a proof before answer of its averments, but an extra division of the inner house of the Court of Session reversed her decision and dismissed Batley's action as irrelevant. Batley appeals to this court. This court unanimously allows the appeal. In relation to the first question, it concludes that the inner house erred in holding that Batley had to give written notice before the subtenant became under a duty to keep the premises in a tenantable condition at all times. The inner house imposed on Batley a hurdle which wasn't there. No such notice, written or otherwise, is required. In this regard, Scots law adopts an approach similar to English law, as Lord Penrose held in two first-instance decisions with which this court agrees. In relation to the second issue, this court holds that the minute of agreement did not require Batley to give written notice of its requirement that the alterations be removed. The minute of agreement, which was a consent to alterations, operated in the context of the leases which governed the rights of the parties, that is, the head lease and the sublease. They were part of the factual matrix and required many communications between landlord, tenant, and subtenant to be in writing. But the minute of agreement is a separate document, and the correct starting point of contractual construction is an examination of the words in that document which the parties have chosen to express their agreement. Those words showed that the parties had agreed that the intimation of the requirement did not have to be in writing. This made business common sense in a context in which the subtenant would, in any event, be considering its repair obligations at the end of the sublease. While the use of writing would have given the parties a greater degree of certainty, the parties had chosen to allow a less formal intimation of the requirement. Accordingly, Batley is entitled to an opportunity to prove its averments that its appointed surveyor had intimated to the council its requirement for the removal of the licensed alterations and the reinstatement of the sublet premises.
That completes the judgments that the court delivered this morning, so we now adjourn.